The difference between a request for evidence, RFE, and a notice of intent to deny, NOID.
Hello, greetings. I am Attorney Edwin Fogam, an immigration attorney. Today I wanted to touch on the difference between a request for evidence, which is generally called an RFE, and a notice of intent to deny, which is generally referred to as a NOID. These are requests that USCIS may send to an applicant while processing your application. Now, what is a request for evidence, or an RFE as it is generally referred to? A request for evidence simply means that USCIS is in the process of adjudicating your application. However, some additional information is required to complete the process. Many times, this is not necessarily bad, especially if it is just some minor documents to submit, and responding to them will solve the problem and your application will be completed and you could obtain your status very easily. However, there are some requests for evidence, especially in employment-based visas like EB2, National Interest Waiver, that are heavy. The content is very tough and you have to respond to them. How is this different? Request for evidence, how is that different from a notice of intent to deny? A notice of intent to deny, or a NOID, is actually a notice that USCIS gives to you, letting you know that the service is inclined to deny your petition. In other words, your application has been adjudicated to the point where it has been determined that there are reasons to deny the application. However, some regulationary provisions require that they give you a chance to respond to that intent to deny, and you have to respond to them. So how do you address these two types of requests? First of all, a request for evidence, it depends on what is actually being requested. As I said, in some cases, like employment-based, there are some serious documents or information that are required to address the request. In this case, you have to really get into some serious analysis and preparation of substantial documents to respond. But in most cases, an RFE is easy to respond to. But for a NOID, or a notice of intent to deny, it requires very, very careful and intense preparation, because almost 75% of the time, it will be denied if you don't really respond to what the intent to deny is asking. Because at this point, the USCIS has already reached a position where they think this application is not acceptable. So I hope these differences make sense to you, because it is important to always keep this in mind and to know when to seek assistance or legal counsel, and not just to respond to what USCIS is asking of you. If this was helpful to you, please share it so that others may benefit. And if you need any assistance, please contact us. Our phone number is 301-608-1555. You can also send us an email to ekfogam@fogamlaw.com or info@fogamlaw.com. Thank you, and I'll see you again.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.